go. Let's see if this works. I don't see that we're streaming.
Yeah, I have the YouTube page pulled up, but
You don't see us streaming either, right?
Excuse me?
You don't see us streaming.
That's correct.
Okay.
I imagine that would be, like the first thing that would pop up.
Right. Yeah, hold on. Oh, where? What page? What page were you on?
On the, hold on, I'll go back. It looked like the main video page. It was like the second, like the main page is the video page. This was the second.
Okay, let's see here. Here we go, live. All right. Looks like we're on. So, want to say hello to everybody. Hopefully, let's make sure we can hear us. I know I have us quiet there. Good. So I want to thank everybody for joining us today. We're here. It's myself and Mr. Ryan Toogood from my office. Ryan, say hello to everybody. We're here. It's myself and Mr. Ryan Toogood from my office. Ryan, say hello to everybody.
How are you? I'm Ryan Toogood.
So today we're here to talk about the emotional support animal issue. And this is an issue that affects associations left and right, and frankly affects owners left and right as well, when there are people wanting to have emotional support animals in your condos, in your sometimes even HOAs that are more set up as condos, townhouses, villas, and so forth, where you have rules and regulations or covenants that restrict the ability or the right to maintain a dog or a pet in your residence. Our office has, to some degree been very strong on behalf of associations when it comes to these issues. We really look to resolve these issues in a fair and equitable manner, but to make sure that the owners petitioning them really put forth something of a need and a necessity. So Ryan, up, and we're gonna go pre this newly adopted laws, the ESA laws, emotional support animal laws of here in Florida, this June of 2020, to how we did things previously. So if you could start first, but kind of introducing how we approach this, what kind of things we looked at in the beginning, to give everybody kind of a feeling of where we've come from, and then we'll go to where we're going.
Sure. So before the new law, which goes into effect on July 1st, 2020, we would deal with things on the basis of the Federal Housing Act and the Florida version of that. There was no explicit mention of emotional support animals, and for the purposes of this video, I'm probably going to just refer to them as ESAs, for brevity. And the analysis would be A, whether the claimant for an accommodation, supposing that an association had a restriction prohibiting animals. The analysis would be A, whether the claimant was in fact disabled, and two, whether the requested accommodation was both reasonable and necessary. And that tracked the language of the statute, both the Florida and the federal versions. They were, pretty much similar. And in doing so, the test to determine whether or not someone is disabled is whether or not a major life activity is impacted by the symptoms of that disability. For example, sleeping, eating, being able to socialize, just anything really that, one would consider an integral part of one's daily, day-to-day life. Having established that, we would then try to establish the nexus between the symptoms of that disability and the effect that the emotional support animal would have on those symptoms. So the inquiry would not just be, oh, okay, you're disabled, you are entitled to an ESA. It would be, does that ESA mitigate, ameliorate those symptoms such that without that animal, you would not enjoy an equal opportunity to use and enjoy the dwelling. So with that sort of framework in mind, oftentimes we'd get a request. It would oftentimes be incomplete. Sometimes it would just be a pretty simple certificate from the internet saying that, their dog has been trained as an emotional support animal and so on and so forth. Or maybe even a rote doctor's note that said, I recommend this person have an ESA because basically they want it. In those situations where we had incomplete information, we would then send out not a form, but a questionnaire of sorts to determine what exactly those major life activities were, why this dog in particular is necessary to mitigate those symptoms, why there aren't alternatives available such that perhaps an accommodation isn't even required. For example, some people would say, oh, well, I have a disability and it makes me very lonely. Well, but perhaps in that situation, you also live with 6 other people. So there'd be a question of reasonableness. Well, don't those 5 to 6 other people, also provide that same ameliorative effect? And we would do it on a case-by-case basis to determine essentially, A, whether it was in fact necessary, whether it was reasonable, and whether, again, there was that nexus between the symptoms of the disability claimed and the beneficial effect provided by the ESA. And again, that was all based on the prevailing case law that provided that an association has the right to, inquire and exercise some discretion in making this judgment.
So how far could we go in to asking questions? How intrusive or unintrusive, if you will, could we request applicants get into their medical background, their necessity, their treatment plans, alternatives that they were using or looking at to be able to ameliorate their issues without needing a support animal?
Fairly intrusive, if you will. Now, after the Department of Housing and Urban Development, HUD, issued guidelines saying that you could not, in fact, ask for someone's diagnosis, you could still, in fact, ask what those major life activities were impacted. You could, in terms of your analysis of reasonability, you could ask things like, how long have you had this disability without exactly requesting an identification of what that disability is, but you could ask how long you've lived and, with this animal, lived with this disability without the animal. The implication being that if you've lived for 30 years with a certain disability, it's not necessary. We could ask about why a particular emotional support animal was necessary. For instance, if someone wants to bring a 100-pound dog, we could ask why a 25-pound dog wouldn't provide the same therapeutic effect. Because part of the law too is that a person isn't necessarily entitled to the ESA or accommodation of their choice when other reasonable options or alternatives are available. And that's a large, that's going to be a problem. You're talking about condominiums that can have narrow hallways, they can have limited outdoor space, they can have thin walls. Sometimes the size and breed of the dog can be a real issue. And part of the problem is that a lot of people would sort of discuss their attachment to a particular animal as if that were the disability itself. It's sort of like, well, I need this dog because if I didn't have the dog, I'd be sad without it. Well, sure, but being sad about the loss of the dog in and of itself is not a disability. So it would go to the original query, what in fact is the major life activity impacted by your disability? We would often ask permission to speak with any recommending physicians or healthcare providers that provided any information to determine the extent of their treatment of the individual requesting an accommodation. So in short, there was not much limitation in terms of what we could ask, largely in part because the law in effect at that time did not address those issues.
And from a standpoint of either a HUD or the Office of Equal Opportunity, it's fair to say that those organizations are fairly liberal in reviewing these types of requests and applications for a reasonable accommodation, are they not?
I would agree with that, especially perhaps less so HUD, but certainly in the Offices of Equal Opportunity.
So even with all of the rights that the associations had to request information, to get information from these owners as applicants, going through whatever histories, whatever needs, necessity, and so forth, it's fair to say that the OEO, the Office of Equal Opportunity, would, to some degree, look at all that information and say, nevertheless, it's our edict, it's our understanding from HUD, from those above us, that any basic request should be granted to some degree.
Not exactly a rubber stamp, but even if you had some sort of pretext, if you had provided the material, then I would agree with that, absolutely. Certainly OEO does not, to me, in the history of our dealings, seem that enthused about making an investigation or really thorough inquiry into the reasonableness factor. Especially if someone can actually demonstrate a disability by virtue of a doctor's note, some information from a healthcare provider. The trend had been, well, who are you to question, if they say that dog helps them alleviate their anxiety and so forth, the tendency would be to side with the person requesting an accommodation.
And that's really an important factor and something to note. If the applicant, the petitioner, doesn't provide any information after you request it or we request it as the firm, as saying, listen, give us your doctor, your treatment regimen, whatever it may be that's reasonable and permissible under the law. If that person refuses to give that information, I think then the OEO, would you agree with me, really sides with us and says, you know what, you've asked for it, they had an opportunity to provide it. Because they didn't, you didn't have the right tools within your ability to look at and approve or disapprove their application, correct?
I would agree with that as long as the association could demonstrate that a dialogue was open, was pursued. If an association asks once, hey, listen, we need extra materials, and they don't get a response, I'm not sure that would, suffice in terms of the necessary dialogue that needs to occur between the housing provider and the person claiming the accommodation. But when there comes to a certain extent when a person refuses, says, basically, I learned on the internet that I'm entitled to this emotional support animal, and there's nothing you can do, to stop me, or you're not allowed to request this information. A lot of times, the authority would say, well, it's not that you even failed in a procedural way, it's that you've refused to cooperate. And in those cases, absolutely, the association would often be on the prevailing side.
Ryan, we got a question. Can the association limit the size and type of animal? So that gets into I want a miniature horse to help me, or a pot-bellied pig, or I need a lion as my emotional support animal.
So that depends. So the law now, especially the new law that's going to be effective next week, is clear that it's the particular animal that is the query. It's not just are you entitled to any emotional support animal. It's whether the particular animal is in fact the animal that ameliorates your benefit. So let's say you have a mini horse, and a doctor provides, confirmation that in fact that particular animal is necessary for you to enjoy equal enjoyment of the dwelling. However, there's also the standpoint of reasonableness. If in fact you have an animal of a certain size or character or type that's going to is going to result in damage, is going to result in excessive noise and so forth, then there could be an argument to exclude on the basis of reasonableness. However, that is mitigated a little bit by the fact that the new law does specifically state that a person with accommodation retains complete liability for any damage that the animal might cause to person or property. But the other point that I would say is that the law, I'm sorry, I just lost my train of thought. The law does state that ESA can be restricted on the basis of safety to owners and property. So if we're talking about, for instance, if we're talking about an animal that other people are scared of, there could absolutely be a basis to exclude the animal on that, for that danger.
So let me ask you this. So an association then, kind of expounding on that, association says, okay, I tell you what, we have a no pet provision. However, if you need an emotional support animal, and we're going to go in a couple minutes here through what the process is now moving forward with what will be in effect as the law next week, but within those parameters, we want to set a blanket policy that your animal must be a non-aggressive pet. We list what those pets are, and we say less than 30 pounds because of the type of building. Either we're in a condominium with closed catwalks, closed hallways, elevators, where we don't want to have the dogs be a problem. Can we set up and say, as long as you pass it, it has to be less than 30 pounds? And you're saying no.
I don't believe so, no, because if in fact the applicant could establish with the proper documentation that a certain animal that was, let's say, 35 pounds that particular animal was necessary for their enjoyment, I would say a strong argument could be made that would be in a reasonable accommodation of any restriction in the weight or size of the animal. Again, within the limits of reason, there's always going to be, some gray area. If someone has a bull mastiff or, again, a miniature horse or something, there's going to be, more opportunity for argument. But in terms of bright line restrictions like that, I would not recommend that, especially because the new law states that as part of the accommodation request process, associations or housing providers cannot use formulaic application processes or require specific forms and so forth. And so any, before the fact restriction on what an ESA could actually, what kind of ESA could be allowed, I don't think that would be supported by the law.
So let's talk, before we talk really openly about the new law, broadly about it, let's talk about some of the differences between the old law, which is currently still the law if there was an application today or tomorrow, and what will be in force next week. Just kind of
sure. So the first thing is that this new law actually recognizes emotional support animals as legitimate, recognized accommodations, whereas before, as I said from the very beginning, the previous process was just fitting the emotional support animal into the the analysis of what a reasonable accommodation would be. That said, the biggest, another big difference in the law is that there are certain restrictions now on what you can ask. For instance, now, and this is consistent with HUD guidance that was issued in 2020, but you are not allowed, in fact, to ask an applicant about their diagnosis or the severity thereof. So any inquiry into the request is going to have to be couched in terms of not what your diagnosis is, not the severity of, but rather what major life activity has been impacted such that you need an emotional support animal. Also significantly, there is no longer the ability, well, this was never in the law, but there is now affirmative law that states just because you have an internet certificate establishing that your particular animal is registered as an emotional support animal, it has been confirmed, or such sort of, language to that effect, that's not adequate by itself to establish the necessity and reasonableness of your request. Similarly, the new law actually creates new criminal penalties for those who would provide fraudulent information in support of their accommodation request. It's actually now going to be a misdemeanor under, I think it's Chapter 817 in the Florida Code, where anyone, including healthcare providers, who were to provide bogus information in support of their request can face criminal penalties. And not only can housing providers face those same penalties, there's also a separate section that they can be professionally disciplined, for not being able, or for not having offered this information with the personal knowledge of the applicant and their diagnosis. Another important thing is, especially in Florida, where we have so many people coming from out of state, we have the snowbirds and so forth. If someone is going to rely as part of their material supporting their accommodation request on an out-of-state healthcare provider, and that especially applies to some of these internet operations where you can, go and basically get a rubber stamp and pay some amount of money and then say, yeah, this person needs it. That out-of-state provider needs to have personally seen the applicant at least once, which is going to be a roadblock for a lot of applicants, because a lot of the applications I've seen in the past, especially the out-of-state ones, there's never actually been an in-person, treatment, an appointment, anything like that.
Would that apply also in-state, that if I said I've been going to, Ryan's wife for psychological treatment, and your wife says, I've never seen Guy, he called me one time, asked me for a prescription, and I gave him a script. Would that suffice, or would that also be under that same test as in?
There's a little gray area. The in-person requirement doesn't apply. However, there still needs to be personal knowledge. So, and not only of the personal knowledge of the diagnosis and the animal, but also the recommendation has to be within the actual day-to-day practice of that practitioner. So if you go to a chiropractor and, again, even in state, and say, here's all my problems, this is why I need it, arguably that person would have personal knowledge, but if they're failing to provide supporting information for an emotional support animal on the basis of, for example, anxiety and so forth, which is the basis of a lot of these sort of emotional support animals, it makes sense, emotional support, that, pretty convincingly, arguably, that's not going to be in their practice, and that's not going to be able to be reliable information on which the association can rely. That's another part of the law. The association retains discretion to make these evaluations and can, sort of make judgments about what information has been provided is in fact reliable. So for instance, my husband's cousin's brothers, got a doctor and he sent me a note. There's going to be several avenues of attack to challenge that supporting documentation if an association is, dubious about the legitimacy of the accommodation request.
So before we get to it, I want to run through an example before and after, and of course we can't give legal advice because every case, every situation, every circumstance has its own nuances and own issues that would have to be vetted in order to really give a proper opinion. But for a question that we've received on the chat board is, can now, with the new law, an association limit the number of emotional support animals a person has? I know we had a case a long time ago where the owner had 2 dogs, and they described one as a pet and one as an ESA. Would that be able to change now? Is that more difficult with the new law, or is that
the law specifically states now that if you're attempting to have multiple ESAs, you need to have the independent justification and support for each.
That's terrific. So it makes it more difficult for the person saying, Fluffy and Buffy are my 2 dogs and I love them both and I can't get rid of either one of them. They're my emotional support animals. Or in an association that allows 1 but not 2 to say that Fluffy is my pet and Buffy is my emotional support animal. Now that wouldn't fly.
And my response to that would be, you don't need an accommodation, because if there's a 1 pet restriction and I understand that the law says that an ESA is not a pet, but if you are in fact allowed to have your animal, your ESA, no accommodation is needed for you to have an additional pet.
So if I come in now and I'm moving into this condo, it's a terrific condo, and I want to live there, and I have an animal, and they do not allow any dogs, any pets in this association, and I provide a letter from my physician that says, Guy needs an emotional support animal based on my analysis and my diagnosis of Guy. He meets everything from the DSM. I think it's up to 4 or 7 at this point, whatever it is, from the DSM guidelines. He absolutely meets them, and I find he has high anxiety, high social adjustment issues, and an emotional support animal that he has chosen assists him with that. What could we do now that we couldn't do before, now being next week, that would help the association to properly vet if in fact that's true, and if in fact guys should get the emotional support animal? Also thinking about the fact that I know in the past we would always look to see, when did I get the dog? When did the script, the diagnosis come from the doctor? How long have I had the dog before that? And where was I on medication? Was I on other treatment before this doctor diagnosed me with these anxiety issues, 3-4 years after I purchased the dog, or if in fact the dog was purchased at the time of the diagnosis?
So some of those queries are going to have to be limited, because first of all, the law specifically states that you can have obtained the ESA before or after even you've moved into the unit. Second of all, it states that no prescription is necessary. How I would attack that situation would be to ask the questions about the personal knowledge of the physician itself. What is the treat? Well, it's difficult because you can't ask for the diagnosis, but you can at least ask. First you could ask permission to speak to the healthcare provider, and you can ask whether you have personal knowledge of both the particular emotional support animal.
Oh, I think we're losing you a little bit here with the internet. Oh, you're slowing down, Rye.
In terms of, asking about what kind of treatment you have been in and so forth, I feel like that's going to be out of bounds based on the inability to inquire about the diagnosis.
Just real quick, we lost you a little bit with the Wi-Fi connection. If you could go kind of reverse back about 1 minute worth of what you were talking about. You were saying, you brought up 2 good points. We can ask the doctor to speak with the doctor, and then we can ask you yet another comment about the doctor. What if I say, I don't want you speaking with my doctor? Does that negate my application?
No, but, well, first of all, you can also, the association is allowed to look at the history of correspondence with the applicant in making a judgment about the truthfulness and reasonableness of their request. So perhaps if there's been any history of dishonesty, if maybe they, were, put something on their lease application, for instance, that proved to be, dishonest, that could be part of it. But it's going to depend on eventually the association's appetite for, a litigation risk, because you could, there's nothing in the law that says the applicant has to provide the permission for the provider to speak to their healthcare practitioner, but so you'd be limited to asking the actual claimant himself about the veracity of this information. Does your when your doctor